Okay, everyone can see that, yeah? Can you see that?
Yeah,
Guys?
we can.
Fantastic.
We can. So as our attendees are coming in, welcome everyone. My name is Gail Fast, and I oversee trainings for the Office of the Advisory Neighborhood Commissions. Just as a sort of housekeeping, many of you who have attended our sessions before know how to do this, but we do have ALS interpreters today, and Matt is one of them. He's doing it right now. But what you need to do so that he remains on screen, if you do need interpretation services, is to hover over his picture right now. He's at the top of your screen, and you'll see three dots that will say more options. If you click on them, there is one that says move to stage. And what that means is then that Matt will remain at the top of your screen, and you'll be able to see him throughout the entire presentation. We do have another interpreter as well. Her name is Marin. She hasn't come in yet, but as she does, I will also have her as a panelist, and eventually you'll be able to see her up on screen. You will have to pin her as well, because as she comes on, Matt will disappear off the screen, and you'll want to be able to see her. So the two of them will stay up at the top of your screen. So we're going to start in about 2 minutes. Alex, Lily, can you start without Max, or you need to wait for him? He
Oh, no, we
hasn't.
can start without him for sure.
Okay, because he hasn't come in yet. I'm still looking for him.
He was having issues with WebEx, but we are in the same room, so he's here.
Oh, okay, great. So we don't have to wait for him. Okay, wonderful. So we're just going to let some more attendees, give them 1 more minute. We had about 35 sign on. That usually means we get about 20, so we're close, about 16. So I'm just going to give everyone 1 more minute. It's good to see everyone on 54 degrees on May 3rd, right? I'm freezing. I tried to look for a background of snow. I thought that would be appropriate for today's presentation. A winter scene in the background, but couldn't find one.
I heard Western Maryland got about 2 inches of snow.
Yeah, that's what I saw. I saw a picture of that.
Yeah.
Okay. Okay, well, it's 4:05. Everyone's time is valuable, and this is a roundtable that we hope to have and warranted discussion. So let's begin. And I'm going to do some housekeeping and some introductions, and welcome everyone. So welcome. My name is Gail Fast. I'm program analyst at the Office of Advisory Neighborhood Commissions, and lead most of the trainings that occur from our office. Today, we are joined by the Office of the Attorney General's Equitable Land Use Section. Many of you know them. We have Alexandra Kane, Maximilian Tondro, and Lily Bullitt here to talk us and walk us through a zoning case number 22-25, which is scheduled to be in front of the Zoning Commission on June 12th. Okay, so just a little bit of an overview of what we're going to do today. The ELU unit does have some slides. They're going to run through those, but there will be points throughout the presentation when we will open it up for discussion. So as you all know, discussion is done since you're all have come in as muted. You just use the raise your hand emoji, and then I will unmute you. You'll be able to ask your question, and then we'll move back on through slides, probably another stop point, more discussion, and then I believe we have discussion for final questions at the end of the session. We've scheduled this for an hour and a half. We do have a hard stop though at 5:30. So we just want to make sure we get all the information in. Just sort of as a context before we start, the Office of Planning and Office of Zoning are proposing changes to the Board of Zoning Adjustment, or the BZA, and Zoning Commission, ZC generally you see that as, procedures in zoning case number 22-25. The most recent draft text has been updated to address some of the initial concerns raised by ANCs, OAG, and residents, including lengthening the ANC notice period prior to the set down from 35 to 45 days, deleting exceptions, for OP and ANC map amendments to undergo set down, and clarifying the standards of motions for rehearing and reconsideration. However, there are still a number of proposed changes affecting ANCs, and those include public participation, noticing to ANCs, modification cases, racial equity analysis requirements, and appeals of zoning decisions. So I believe we're going to touch on a lot of those today. And again, one last further housekeeping for anyone who needs interpretation services. You've heard this before. You need to toggle over Matt, who is interpreting right now, at the top of the screen. There are 3 dots in the top right-hand corner. You click on them and say move to stage, which will leave Matt at the top of your screen. There is one other interpreter. Her name is Marin. She has not arrived yet, but when she does, I will also place her at the top of the screen, and you'll have to pin her as well, as they will be trading off and on from each other. So without further ado, I'm going to turn this over to the Office of the Attorney General's Equitable Land Use section.
Thank you, Gail. I just want to confirm one last time that you can see the slide that says ZC case number 2225.
We can.
Fantastic. Okay. Hi, commissioners. Nice to meet you. My name is Lily Bullitt. I'm here, as Gail mentioned, on behalf of the Equitable Land Use section of the Office of the Attorney General. We're here today to talk about changes to the zoning procedures. As Gail just mentioned, the Office of Planning and the Office of Zoning, or OP and OZ, as I'll refer to them, have proposed changes to the regulations, the zoning regulations in case number 2225. A little bit of background about the case. OP and OZ have been discussing many of these changes since 2018. They filed a case back in 2019, but that did not become finalized, and so they refiled it in July of 2022. It went to a hearing in April, and in advance of that April hearing, OAG, many of you ANCs and members of the public reviewed the proposed changes and submitted comments. And then at that April 3rd hearing, OP and OZ recognized that they needed to change their proposal, and they delayed the hearing until June 12th. And so about 2 weeks ago, they submitted an updated proposal. And so I'll go through today what was in the original, what was in the updated proposal, and what OAG still sees as concerns. As I mentioned, these changes have been under discussion for about 5 years. And so these types of changes to the regulations do not happen frequently. We really see this as an opportunity for the public to voice their views on how they want this to improve the zoning process. OAG has thoughts, which I'll discuss today, and proposals on how to improve it, but this is a roundtable, so we want to hear from you on what issues you have had with the zoning process and how they can be addressed. And so, as Gail mentioned, I'll stop at a few points throughout my presentation and we'll open it up for questions and discussion. Okay, so OAG's feedback and recommendations in this case all revolve around encouraging more public input and more equitable public input. We want the public input to occur earlier in the process so the community and ANCs have more opportunities to meaningfully engage with applicants or petitioners. We propose encouraging this by requiring earlier, more substantive notice to ANCs and the public, and creating one uniform procedure for all case types before the commission and one uniform procedure for all case types before the board. As a result of earlier meaningful participation, opposition can be addressed sooner, and the process is more likely to avoid lengthy appeals at the back end of the process. So in this case, OP and OZ are, this is just a shortened list of everything they're proposing. It's about a 35-page public hearing notice. If you've looked at it, we'll send it around along with this presentation. But there is a lot in here. OAG has gone through it, and today I'm going to be focusing on just the main parts that we see as particularly impactful. You can refer to our comments that are filed in the record for a more detailed explanation of what they're doing. So I'll first go over pre-hearing procedures, including modifications and our recommendation to have one procedure for all application types with only very minimal exceptions. Then I'll talk about racial equity requirements, and finally, the rehearing and reconsideration standards and procedures. So first up is pre-hearing procedures. OAG's main concern with the Zoning Commission's pre-hearing procedures, as they are written now and as they're proposed in this case, is the lack of meaningful notice to the general public early in the zoning approval process. Now, too often the public learns of an application or petition merely a few days or weeks before the hearing date, and OAG hears all the time that by the time an application or petition gets to the hearing stage, it is already fully baked, meaning the project is no longer flexible enough to incorporate or address concerns that are raised at the point of the hearing. Thus, anyone in opposition at that point are more inclined to file an appeal in order to have their concerns addressed. The appeal process is lengthy and can delay zoning approval by 2 or 3 years, and it's really a lose-lose situation where those having their concerns don't actually end up having their concerns addressed, and those seeking approval have to wait 2 or 3 years, sometimes abandoning the project. So to avoid those lengthy appeals, or at least to lessen their likelihood, OAG proposes providing meaningful notice with easily understandable information about the project to the general public early in the process. This will encourage the public to participate in the process early on and provide more opportunities to resolve any concerns, which will lessen the chances of appeals. Not every case has an NOI. Under the current regulations, we're proposing that where currently the NOI happens, that's when the meaningful public notice goes out. Some cases require NOIs, some require set downs, some cases can skip one or both of those steps. Some can change what type of case they are halfway through the process. It's very confusing. And all of these varying procedures make it difficult for the public to understand a case's requirements and what opportunities they have to participate. So to further encourage public participation and transparency, OAG is recommending that all cases undergo one uniform process with substantive notice at the NOI stage. So this slide illustrates OAG's recommendation of one uniform process for all case types before the Zoning Commission. I'll talk about our proposal for the board in a minute. Under the current commission procedures, notice to ANCs, notice to the public, and the filing of publicly available project plans all occur at different points in the process. OAG is proposing that notice to the public, notice to ANCs, and the filing of publicly available project plans all take place at one point in time, and that is at the beginning of the process. Currently, applicants send an NOI 45 days before filing an application, but the NOI only goes to the affected ANC and property owners within 200 feet of the subject property. The NOI contains literal substantive information about the project. It just gives a heads up that a project is coming. It is not required to have project plans attached to it. And at that point in time, there's no publicly filed project plans or case record or tracking number. So if anyone who receives an NOI wants to learn more about what is actually going to happen at this project, their only recourse is to contact the applicants or the applicant's lawyers, and then they have to rely exclusively on the applicant or the lawyer's representations of the project with no means of independently assessing the case. Many applicants meet with ANCs around the time that the NOI is filed, and they may provide project plans or an overview of the project, but not all applicants do this. And OAG is seeking to create a minimum standard requirement in the zoning regulations so that those plans are publicly available in all cases. Furthermore, most of the wider public do not receive NOIs. NOIs only go to the ANC and property owners within 200 feet. And so if you're a neighbor that lives, for example, 300 feet away, you are not going to be notified until much later in the process. So they are not able to contact their ANC at that early stage in the process when the ANC is deliberating with the applicant. The ANC doesn't have feedback from the wider public at that point, and we're trying to solve that issue a bit. So at least 45 days after the NOI, the application is filed and the project plans become publicly available. when that happens, there's no notice to the wider public unless a member of the wider public is regularly checking the OZ website or reading the DC Register, which most normal people don't do, from my understanding. I'm not normal. So once the project plans are publicly available and people can actually learn more about what's happening in the project in terms that are more easily understandable, there's no notice to the public that that's happening. So again, the public is unlikely to contact their ANC at that point. It's not until 40 days before the hearing that notice is posted on the property, which tends to give notice to the wider public. Anyone that's walking by that maybe is a neighbor living close by but not within 200 feet will see that sign, realize something's going on, and then has the ability to contact their ANC or voice their opinions to the zoning commission. But again, at that point in time, the application is fully baked and it's difficult for the applicant to incorporate that feedback or for ANCs to incorporate the feedback of their constituents. So OAG is proposing that notice to ANCs and to the public be provided at the same time as the project plans become publicly available. Just want to be sure the interpreter is still available. I don't know if I'm seeing the whole screen, but I can pause a minute if that's, yeah.
No, we've got it. Marin is here.
Thank you.
And so folks, you can see Marin is on the screen if you need her. Again, just hover three dots, click move to stage, and she'll remain on there, and her and Matt will figure out their trade-offs. Thanks, Lily, for mentioning that.
Sure, thank you. So in OAG's suggested procedures, the NOI and application filing are combined into one notice of filing, or NOF, that provides substantive information to the public early on at the same time that they're notified. The NOF will be, under our suggestion, will be provided at least 80 days before the set-down meeting, and this will not increase the length of the pre-hearing procedures. Even under the current regulations, which only require 35 days between filing and the set-down meeting, most cases are not set down for 3 months anyway. And so our proposal to allow that time to be 80 days will not extend the process in practice, but will provide more time for ANCs to review the application, for the ANC constituents to review the application and then contact their ANC, and thus there's more information in the record by the time set down comes around. We hear often from ANCs that the current 30-day deadline to complete the set down form is insufficient. ANCs have a variety of meeting schedules, and depending on when the application is filed, may not even meet within those 30 days that's currently required, 35 days. So there's 35 days between the time, but 30 days to file the set down form. On top of that, some ANCs have zoning subcommittees which need to review the form first, which extends the time needed to complete the form. So 30 days is really not enough from what we hear from ANCs. The 80-day NOF period that we are suggesting will increase the time ANCs have to review a project and allow them to provide more meaningful feedback to the commission at set down. The commission, in turn, will have more information available to it at the set down meeting, and can use that information to identify issues that it wants the applicant or petitioner to address at the hearing. More feedback at set down gives the commission more information on which it can base its opinions, and also helps to avoid surprise opposition at the hearing. Again, extending the pre-set down time to 80 days will increase transparency and public participation with no significant burden on applicants who are already wait around 3 months for their case to be set down. Additionally, one process for all case types would vastly simplify the process and make the procedures easier to understand and thus more accessible to the public. I will note that in OP and OZ's updated proposal, they have increased the time that ANCs have to file the set down form from 30 to 40 days. While this is commendable and it's great that they're listening, OAG is still of the opinion that a uniform process giving 80 days notice, which would not extend the pre-set down time in practice, is a better option given the ANC's varied schedules and the need for early public participation. I know that was a lot of information. I'll pause in a minute for feedback and questions. So OAG is similarly concerned that under the current regulations and as they're proposed in this case, notice to the general public does not go out for BZA cases until 15 days before the public hearing when the property is posted. even though the application is filed 25 days prior to that. So again, we have this disconnect between when publicly available information happens and when the public is actually notified. OAG recommends that notice to the general public occur at the same time as the application is filed, and that we extend the time that the property is posted for that entire period. OAG is also proposing that the time between application filing and the hearing be extended from 40 to 60 days. This will allow more time for ANCs to review the application and for the public to raise any concerns they have earlier in the process. Will not delay the process in practice, because most cases are not before the BZA are not scheduled for a hearing until at least 60 days anyway. And this is due to time needed for OZ to review the application and to publish notice in the DC Register. So 60 days is in practice the minimum amount of time that it would take. So by extending it, we're not changing much in practice. The 60-day period also would ensure compliance with the ANC Act, which requires 30 business days notice. And that translates into anywhere between 40 and 45 days when you take into consideration weekends and holidays. Again, 60-day notice would not extend the process in practice, and it would allow more input and review. In coming up with this recommendation, OAG considered longer time periods, 80 days maybe, to be more in line with our proposal before the Zoning Commission. But OAG wanted to recognize that cases before the board tend to be smaller and less impactful. It can be just individuals' property that they're seeking to do construction on. And we don't want to unnecessarily delay the process. So 60 days is where we settled. So as part of our uniform procedure recommendations, and in order to increase transparency, OAG is recommending that applicants and petitioners, including OP and OZ and OAG, whoever, if you're a district agency, if you're an individual, whoever is the applicant or petitioner, meet with ANCs within that 80-day or 60-day time period between the filing of the application and the public hearing or the set down. Currently, applicants tend to meet with ANCs prior to filing an application when the general public is not yet on notice and when the case record is not yet created. This means the public does not have an opportunity to contact their ANC while the ANC is considering a project. And ANCs are limited to the information provided to them by the applicant, as opposed to the complete plans and justification in the full application package. OAG's recommendation ensures that applicants meeting with ANCs happen at a time when the public is on notice and has meaningful information available to it. This will not unduly burden applicants who are currently required to make efforts to meet with ANCs prior to filing anyway. So just as a side, this is, I want to make sure everyone is taking notes, because like this is our proposal and this is a roundtable. So we'd love to hear your feedback on this. If the petition is affecting, petitions can be text amendments, for example, like the case that we're discussing now. If it affects more than 5 ANCs, we're suggesting that the applicants or petitioners can host a session similar to what we're doing right now with OANC to satisfy the requirement of meeting with ANCs. We think that even if it affects more than 1 ANC, that shouldn't be a reason to not meet with ANCs. And if ANCs are unable to meet with the applicants have to provide proof that they attempted to meet with the affected ANC in order to waive this requirement, just to make sure that they are making a good faith effort to meet with ANCs and discuss their proposal. Again, as part of our uniform procedures that OAG is suggesting for both the Zoning Commission and the BZA, OAG recommends requiring applicants to make reasonable efforts to meet with tenants of a building that is seeking to be redeveloped or that would undergo construction, such that tenants would have to move. This would ensure that tenants are aware of upcoming construction in their homes and have opportunities to negotiate with the applicant over any potential conflicts earlier in the process, instead of learning about it right before a hearing and then showing up at the hearing in opposition and causing some surprise opposition, which delays the project. We've seen this happen multiple times. OAG is recommending that tenants have automatic party status in cases that affect their homes. Under the current regulations, tenants would almost certainly have and qualify for party status. They just have to be required to file certain filings like 2 weeks in advance or something. By giving automatic priority status to tenants, OAG sees that as essential to ensuring that tenants receive actual notice and have a real opportunity to participate in cases that could potentially displace them from their homes. It allows tenants to raise issues to the applicants and the commission before the hearing, and thus avoid surprise at the hearing.
So Lily, did you want to take questions now, or do you have a set time
I
to?
have one more slide I'm going to get to that all
Oh,
surrounds
sure.
our uniform procedures, and then I'll take questions. Thank you.
Okay.
Yeah. So again, our last note that I want to make about our proposal is that OAG is also recommending that OZ maintain a system that allows interested persons, organizations, ANCs to register on OZ's website in advance to receive notice of case filings and public meetings or hearings. So a member of the public who wants to be involved in their community's development, but who may not be able to regularly attend their ANC meeting, can sign up on the OZ website and receive case updates directly to their email. Under the current regulations, that person may not receive notice until 40 days prior to the hearing. So this just allows an opportunity for the public who are interested to really receive actual notice. OZ's website already contains a similar capability. OAG is simply recommending that this be codified into the process, into the regulations, to ensure that this opportunity is available and to expand what registrants can be notified of. It would also allow ANCs to register to receive notice of cases that are no longer in their district, given the recent redistricting changes. Okay, and that's it. I will love to hear from ANCs. So Gail, if you want to take the lead,
Yep.
I'll go back to the slide.
Yep. So thank you. Thanks, Lily. Okay. So we will take questions on sort of these slides that Lily has put up. So again, if you just want to raise your hand, I'll just take you in order as the questions come up. So the first one is Commissioner Vining. I'm going to unmute you and you can go ahead and ask your question. Yep, go ahead. Commissioner Vining, you're unmuted.
Can you hear me?
Yes.
Thank you for this. This is very important. For years, the community in the ANC has had a problem with the advance, or should I say lack of advance notice to get time for both the ANC and the civic associations that are involved in the ANC. This is very important. I very much appreciate this. During your consideration of these dates, with the goal of trying to have this information available to the public and the ANCs in an appropriately long advance notice, had you considered a problem that we have confronted routinely, which is the problem of August and Christmas? The number of times that a notice comes out around the end of July that nobody sees it because the civic associations and ANCs don't meet. Largely the same thing over the Christmas holidays. For something to flop into the email about mid-December is disaster for exactly the reasons. Just asking if you had considered that.
Yes, thank you for pointing that out. That was actually an oversight on my part for not mentioning that. So one thing that OP and OZ are doing in their proposal, which we think is great, is excluding August from their notice period. So if someone does file something in the end of July and they still are required to give, let's say, 40 days notice, none of the dates in August would count. And then it would start up again in September. So that's a fantastic change that they're doing. In terms of Christmas and holidays, as I mentioned, the ANC Act requires 30 business days notice, so that doesn't include weekends or holidays. And so in our recommendation of 60 days and 80 days, we calculated it, and the longest it could be is 45 days, and that's over the period of, I think, Christmas, January, and then there's, I think, a holiday in early January, or maybe it's like Thanksgiving. There's 3 holidays that could take place within a 30-day business window. And so we did take that into consideration in our recommendations, yes.
All right, thanks so much. Thank you, Commissioner Vining. All right, we're going to go Commissioner Ray. I'm going to unmute you. You are unmuted.
recognizing that it's just your suggestion, but the idea of automatic party status for tenants, can you talk maybe a little bit about how that would work, given that I assume that the boards or the commission would make them a party as one group, which would have to be led by somebody, and how, how would you see that working for them, for groups of people who generally are not familiar with this process and maybe don't know how to, structure their questions in a way that would be helpful for them?
Yes, absolutely. So, in part of our recommendation to ensure that tenants have actual notice, we are requiring that notice to tenants, or we're hoping to require that notice to tenants have include the contact for the Office of Tenants, OTA, Office of Tenants, their tenants assistants. I forget what OTA stands for, but and then also OTA has a list of housing services in the district, and so we're certainly able, hoping to encourage the facilitation of that. Currently, parties do not need to be, they can be one individual person, and so if tenants wish to come forward as individual tenants, that can work. If they wish to form a tenants association and come forward as that, or if they wish to come forward in a not necessarily a formal tenants association, but just as a group of tenants, we believe there's flexibility in the regulations to allow that. I don't know, Alex, if you want to add anything.
Yeah, just to sort of build off of that a little bit, what currently happens in a lot of cases where you do have groups of people who come before either the board or the commission who are sort of in an unorganized group, it's, neighbors. The board and the commission are both pretty good at, trying to sort of help them organize themselves and, designate somebody that's going to be the representative. So you think that it will sort of work itself out, but it's getting them through that initial step of just having that automatic party status so they don't have to jump through all of the hoops of trying to, file the filings that they need to, get everything in on time. It's automatically presumed, and then they can exercise that right if they choose.
Okay, thanks so much, Commissioner Ray. We're going to take the last question on this section from Commissioner Payne. Commissioner Payne, you will be unmuted. You're unmuted. Go ahead.
I just want to say I'm very much in support of all of these changes. It would have been really nice had this process been in place a few years ago. My question is, will this case number address any recourse that community members can make if they feel like they were not given proper notice and changes have already been made to buildings in their neighborhood?
So just so I understand what you're saying, like, for example, someone, a community member didn't receive notice, the application has gone through and has received a final order, final approval, and now they're seeking some kind of recourse. Is that right?
Yeah, like the projects have already been finished.
I believe that's a bit beyond the purview of what we're able to do in this case. We will talk a little bit about motions for reconsiderations and rehearings, but that's only within a 30-day or 10 to 30-day window after the final order has been issued. If the change has already happened, like if a building has already gone up or undergone construction, I think that, and Alex, correct me if I'm wrong, but I think that's then outside of the process of the zoning process, as long as the applicant has had approval. Notice, a lack of proper notice tends to be doesn't deprive the zoning commission or BZA of jurisdiction, and so one thing that we are trying to do is just really ensure that the community gets actual notice, because of exactly what you're saying, is like, even if they don't get notice, changes can happen, and then there's no opportunity for real recourse necessarily.
Okay. Thank you.
All right, wonderful. Well, that seemed to work for this section. So we'll let you now, Lily, move on to the next section of changes that you're looking to implement.
Great, thank you. So next I'm going to talk about some changes that OP and OZ are making to modifications, and this is once a final order has been approved, has been issued, and then an applicant or petitioner is looking to come back and make a change to that final order. So in this case, OP and OZ are proposing to change, one thing they're doing is proposing to change the language from modifications of significance and consequence to modifications with and without a hearing. I personally think that's great. Every time I'm dealing with modifications, I have to look up, is significant bigger, consequences bigger, and we think that modification with and without a hearing are much clearer language, easier to understand, and thus more accessible. We do have two concerns about modifications. First, OAG is recommending that OP and OZ clarify the definitions of modification with and without a hearing. The current regulations contain examples of what would require a hearing, what types of changes would require a hearing, and what can go through without a hearing. But this current proposal is seeking to delete some of those changes, so OAG is suggesting that we retain those examples. OAG made this recommendation previously in response to the first original proposal in this case, and OP and OZ attempted to provide more clarity in their updated proposal, but it seems there may have been a mistake, and I'll discuss that in a moment. OAG's second concern about modifications is a procedural one. An applicant who applies for a modification without a hearing, for which the commission or board later decides a hearing is required. Under the current process, they have to start the application process all over in order to provide the proper notice requirements. And OAG is hoping to avoid that scenario and to make the process more transparent and efficient at the same time. So OAG is suggesting that both types of modifications with and without a hearing go through the uniform notice and pre-set down process that I discussed in the first section. And then once they get to their first interaction with the board or the commission, so either set down or the first public hearing, the commission or board will at that meeting determine whether the application requires a hearing. And if it does, they can schedule one right at that time. And if they instead determine that it doesn't need a hearing, they can just vote on the case at that meeting. And in this way, more parties in the public will have the opportunity to comment on these applications. It will make it more transparent, and applicants don't have to worry about starting the process all over to satisfy the notice requirements after that decision, because they've already met the notification requirements, having gone through the initial notice requirements in the process. So this is the one mistake, well, we think it's a mistake that I mentioned. This is language in the current OP and OZ proposal. It states that for contested cases before the commission, a modification without a hearing is a modification in which impact may be understood without witness testimony, including but not limited to a change in use, change to proffered public benefits and amenities, change in required covenants, or additional relief or flexibility from the zoning regulations not previously approved. So we are immensely glad that OP and OZ tried to address our concern about needing more clarity and examples. But we believe that this was just a mistake because it's in the section addressing modifications of significance, which is now modifications without with a hearing, that this should actually say modifications with a hearing. Nevertheless, OAG is concerned that this language, as it is written here, would allow applicants the ability to make really impactful changes to final orders without public input. ANCs and the public put in lots of time and effort negotiating public benefits, understanding the uses and the impacts of a project, and they should not be changed without input from the ANCs. So a hearing should be required in this case. And I'm going to pause there for feedback. That's a more digestible amount of information, hopefully.
Sounds good. Are there any questions or anyone who'd like to ask anything about sort of the modification changes proposed by the OAG? No questions. I would just like to say from my own personal standpoint, as someone who's been a community member, it's very important. I think ANCs work very hard to put together proffers and public amenities for the good, the overall good of the community. So I think that's glad you're proposing that change. Any other questions? No, we're ready to move on. All right, we'll move on to the next section.
Okay, great. So as I've mentioned, OAG is recommending that there be uniform procedures, and this includes clear application requirements for all applicants and petitioners, including all district agencies with no exceptions or very limited exceptions. So in OP and OZ's original proposal, they had carved out two major exceptions. So first was that map amendments proposed by OP and ANCs were to be exempt from the requirements of Subtitle Z Section 304, which essentially means that they don't have to go through set down or provide NOIs or attend ANC meetings. At the hearing on April 3rd, that was eventually postponed, OZ stated that this was an oversight and they deleted this exemption from their updated proposal, which we are very glad to see. We think that if OP or ANCs are submitting map amendments, then like OP should still have to meet with the affected ANC and still provide NOIs. So we're glad that that was changed. There is one amendment that was not deleted to Subtitle Z, Section 502.1D, which allows ANC and OP map amendments to not provide notice of hearing to neighbors within 200 feet. And so we're suggesting that that change be deleted. And then overall, the second exemption that OP and OZ are proposing is for petitions, which include text amendments submitted by OP or OZ, be exempted from certain provisions of Subtitle Z. I'll go through those in a minute, but OAG previously commented that these exemptions would have significant unintended consequences that allowed OP and OZ text amendments to not be referred to ANCs and to not go through set down. OP and OZ addressed those concerns partially. They updated the list of exempted provisions in its most recent proposal, but OAG believes that there are still unintended consequences resulting from the current proposed language. So OAG is recommending that these exemptions not be adopted, and instead the commission adopt a uniform procedure that applies to all applicants. So if it's a district agency, OP, ANC, an individual, they all have the same requirements. The only exception being that for cases where OP is the petitioner, OP should not have to file a set down report because their application serves as the set down report. And OZ should not have to refer the application back to OP because OP already has a copy of it. So those are really the only exceptions that we see as necessary. So this is the language of the current proposal. You can see that for text amendments for petitions submitted by OP or OZ, are only subject to sections 500.5, 6, and 10 through 16. So in effect, this means that OP and OZ text amendments would not be referred to ANCs. And just to put that into real terms, it means that cases like this that we're dealing with now that are affecting changes to the zoning procedures and ANC's roles and responsibilities would not have to be referred to ANCs. That's particularly concerning to us. The exceptions also mean that the commission would not be able to determine if the text amendment are rulemakings or contested cases, which they currently have the ability to do. So just a brief overview, rulemaking cases are legislative in nature and contested cases have parties that typically affect a smaller, more defined group of residents. But rulemakings can also and have been in the past been determined to be contested cases. Text amendments in the past have been determined to be contested cases that affect a limited number of people. And the commission should be able to determine that and allow parties the ability to get party status and voice their opinions. So we think that the commission should retain that ability. That is, I'll pause again. I'm trying to pause in smaller moments here. So if there's questions or feedback, we'd love to hear your thoughts if you have other ideas as well.
Yes, so we'll take some questions here. And I see that Commissioner Ray has raised your hand, so I'm going to unmute you.
Thanks
And
again.
you're good. Go ahead.
Good, thank you. Well, I think just this case alone kind of shows the necessity of doing notice to the ANCs on text amendment cases. But my question, and this might be a little broader than this case, is on the map amendments where the Office of Planning is the one suggesting the map amendment. Is it me, or does that seem like a pretty solid case? I mean, if the Office of Planning is the one saying that a map amendment fits within the comprehensive plan and they have the plans and the policy documents there, how much real comment is the board actually getting from the community? Because clearly it must meet. I mean, unless they're totally out of, they're going totally out of left field. But what is your feeling on these map amendment cases that are coming out of the Office of Planning?
I have feelings about them. I don't think that, I mean, OP has their role, and before OZ, and I think the commission will give OZ the due diligence, I think, or give the weight that it deserves. But I think that what we're trying to do here is just to ensure that they're not the only voice being heard. If everyone is in agreement with OP and says that before the commission, that's fantastic, but we want to encourage public participation so that, like, if maybe OP is missing something, the public has the ability to voice that. And in order for that to happen, we need to ensure proper notice and ability to participate. And so OP is going to do its job, and we just want to ensure that there's other voices, so that they're not the only ones there, because this is really this is our communities and our neighborhoods, and we think that should be a basis for how the zoning process works, is public participation. I don't know, Alex.
No, I was just going to jump in and say, sort of building off of that idea of getting more community feedback. I mean, the Office of Planning are sort of the designated planning experts in the district, but for map amendments, there are a variety of zones that can apply for a given comp plan designation. So the FLUM will call out different zones, so there may be alternative ones to the ones that OP is proposing. So that would be something that, the community might have, additional insights on, that it would be valuable for the commission to hear about, as well as additional issues as to, whether IZ Plus should apply. The Office of Planning will occasionally recommend against the imposition of IZ Plus. So that would be something that you would want to have community feedback on, as well as, now that we are, incorporating the racial equity analysis, which Lily will get into in a minute, making sure that, that has addressed all the issues. So there is, even with an OP map amendment, plenty of opportunities for the community to weigh in with their insights on what they think is appropriate for that area.
That's helpful. I hadn't thought of that.
Okay, we're going to move on to Commissioner Vining. Hold on, you are unmuted.
Thank
There
you.
you go.
It's Kirby Vining, 5E06. Very interested in the notice about the map amendments, because I've been watching closely in recent years. Several years ago, there were so many of the big projects in town were planned unit developments, PUDs, which gave a full opportunity to the community of the ANCs to engage. And there were so many court cases surrounding PUDs that the mayor and the council both agreed that they would do some massive changes to the future land use map that can help developers avoid PUDs, avoid that back and forth between the developer and the public. If the future land use map has been upflummed is the word that they're used to, for example, high density residential, high density commercial. Now they don't need a PUD. They can just go in and get the map amendment. And it's ever so much more important that we have an opportunity to try to participate in the process there. For example, near my ANC, not in it, but near, if you look at the future land use map for New York Avenue, for Florida Avenue out, the whole thing is marked high density commercial, high density residential, going right by the edge of Brentwood and Ivy City. And what are those people going to do? In a PUD, the ANC there would automatically have party status, but now it's not necessary. This is upflummed. So a simple map amendment that could be missed entirely. I mean, how many people know what a map amendment is? So thank you for taking this into consideration. The comprehensive plan has changed to the point that this is a new process. It's not the PUDs that we knew from yesteryear.
Thank you, Commissioner Vining. I'm going to move to Commissioner Elkins. You Let's try again. Should be unmuted. You're unmuted. There you go.
Me.
Yes, here you go.
Yeah, so
Sorry.
I noticed that you have 40 days for the ANCs to do this, to file a set down form. I thought you had indicated that OP has now gone to 45 days. Is that something that you might be willing to change to 45 days? In my testimonies, I've illustrated that 45 days is the minimum to be able to give every ANC an opportunity.
Yeah, thank you. I'll just clarify because there's a lot of numbers. So the current requirement is that ANCs have 30 days to file the set down form. The set down meeting cannot take place until 35 days after the ANC is notified. And so the ANC has to file the set down form 5 days before, at least 5 days before the set down meeting. OP has increased that from 30 and 35 days to 40 and 45 days. Our proposal is that this be 80 days before everything before the zoning commission, and then 60 days for everything before the BZA. And that includes, there's no 5-day time period between when the set down form has to be filed and the set down meeting. Members of the public can submit comments up to 24 hours in advance of the hearing, and we think ANC should be able to as well. Did that address your question?
No, it's too confusing for me, but I would
Okay.
just call your attention to my filed testimony, which I think, make the mathematical case that if you want to give every ANC the opportunity, once they're notified, to actually take action and file something, it takes 45 days on the calendar. And so I'm not sure, given what you just told me, whether that's a relevant comment or not. I'm sorry. But
Yes,
I would ask you to go back and take a look at it if you would.
Oh, completely. We're suggesting actually much more than 45 days. We're suggesting 80 for cases before the zoning commission and 60 for cases before the BZA.
Right. So if that really covers it, then that's fine. Thank you.
Fantastic. Thank you, Mr. Hawkins.
All right, Lily, that's all for this section. So we're ready to move to the next one.
Great. So next I'm going to discuss racial equity analyses. So as part of this case, OP and OZ are incorporating the comp plan's requirements to perform racial equity analyses into the zoning regulations for the zoning commission. OAG commends this addition. This is required under the comp plan, and we think it's a necessary process, but recommends further clarity of the racial equity process be incorporated into the regulations. So OAG is suggesting that the regulations lay out the whole racial equity process to clarify who is responsible for what aspect of the process at what stage in the process. It's not entirely clear from OP and OZ's recommendations how that works. In codifying this process, OAG makes 4 recommendations which will advance the racial equity goals of the comp plan. First, we are suggesting, so the current racial equity tool, which is let me pause for a second and back up. OP and OZ's requirement is to use the current racial equity tool on OZ's website. OZ updated this tool in February. This tool requires applicants to retrieve data from OP, and this data is disaggregated by race, and it talks about the demographics of the location in which the case is located. OP, the racial equity tool, doesn't state at which stage of the process the applicant should retrieve the data from OP. And so OAG is recommending that applicants and petitioners retrieve the data prior to filing an application. This way, applicants and petitioners can use the disaggregated data to identify communities that have been burdened by racial inequities and direct their community engagement to those communities in the process of finalizing the application. As the case is moving forward, they're using the data to perform outreach at targeted communities. OAG's second recommendation is that the OP community planning section, which is separate from the development review section, provide data that goes back to at least the year 2000. So in discussing racial equity, the comp plan states that implementation strategies should be targeted in proportion to the historical trauma and disproportionate outcomes experienced by these communities. This historical trauma and disproportionate outcome can only be understood by looking at data over time, not just a current snapshot. And obviously, in theory, this could go back to centuries because historical trauma has been going on in this country for centuries. But practically speaking, we think 20 years is a good starting point. And we know for a fact that data exists since the year 2000, looking at disaggregated data by race based on the American Community Survey and the Census Survey. So this is why we're suggesting at least to the year 2000. Third, OAG recommends that the data be gathered from census tracts within a quarter mile of the subject property. Currently, the OZ tool requires data from the planning area, which, as some of you may know, planning areas are quite large. I think there's, correct me if I'm wrong, I think 11 of them in DC, 7. They're quite large, similar to maybe a ward, maybe a little bit larger than a ward. But we think that in order to actually reflect the historical trauma and disproportionate outcomes experienced by a community, that the community has to be defined on a smaller scale. And a quarter mile is what other jurisdictions use in their racial equity zoning tools. Finally, OAG recommends that a narrative be included with the data to explain the data, including oddities and historical events that shaped the data. So for example, if a census tract changed shape and the demographics drastically changed as a result, that would be explained in the narrative. Or if one large tower went up in the middle of one census tract and thousands of people moved in and skewed the data, that would be explained, and it would describe that a tower was built and not that there was some historic event that caused great shift in the population for that census tract. If there were racial covenants or redlining in the area, the narrative could cite that as a reason why the demographics are the way that they are in a certain neighborhood. And in this way, the historical trauma and disproportionate outcomes can be more fully understood as required by the comp plan. So this is an outline of what OAG recommends codifying into the regulations for cases before the zoning commission. So everything in red, that text that you see in red is what we're suggesting, and everything in black is what is actually already required by the current zoning, current racial equity requirements of OZ. OAG is also encouraging OZ to consider what role racial equity analysis will take before the BZA. We recognize that the comp plan only calls out a racial equity analysis be required for the zoning commission, but for development review processes, and it specifically requires the zoning commission to come up with a racial equity tool. But we wanted to call out that BZA cases are just as impactful, and they also are part of development review, and so that doesn't mean that they're exempted from racial equity requirements under the comp plan. I will pause there for questions, concerns, feedback, all the above.
Sure. Okay. I appreciate people are putting comments into the chat. So give me a second. I have to just close something out so I can ask the question in the chat. Okay. So in the chat, the question asked, what happens when a single member district commissioner doesn't reach out to Black and Brown communities and a deadline has passed? What steps should those constituents take to help their voices be heard, and what effect would that have on the ANC's recommendations having great weight after that fact is discovered?
Okay, that's a good question. I'll try to address it in parts. So I think what the question is asking is, in cases where there's an applicant, an individual developer, for example, they undergo the racial equity requirements of retrieving the data from OP and filling out the racial equity tool. The ANC has commented, but hasn't necessarily reached out to Black and Brown residents, constituents in their community. How can they get those voices incorporated? If that's how I'm understanding it, please feel free to correct me, but that's how I'll answer. So the ANC, and Alex, please correct me too, the ANC has great weight up until the final order, and so is issued. And so if you or final action is taken. And so if an ANC realizes that a hearing has passed but still wants to conduct outreach and comment, that's absolutely possible up until a final decision, a final action is taken. So we absolutely encourage you all to do that. There's also, this is one of the reasons that we're trying to change this racial equity tool, is we're trying to have it so that applicants themselves can reach out to these communities, and if they're on notice, they will then reach out to ANCs, and so it can be a two-way street. It's not just ANCs reaching out to their communities, but communities being notified and understanding that their ANC has great weight and that they can speak up to their ANC. So I think all of our proposals around increasing notice and improving the racial equity requirements kind of hopefully make it so that that situation doesn't happen as much. But Alex, I don't know if you have thoughts about.
Yeah, I mean, in terms of racial equity, I mean, as the requirements currently stand, it's currently on the applicant or a petitioner in a specific case to, have the onus of doing that outreach. Now, obviously, if the ANC is the petitioner, that would then fall on them. But in terms of generally reaching out to their constituents, that's not something that's controlled by the zoning regulations. I mean, that's something that the ANC, has to sort of figure out how they want to do that themselves. It's not something that the regs are going to touch from a zoning standpoint. That being said, if, in a specific ANC, there are constituents that feel like they have not gotten notice, or, they have issues with the case, they do have that ability to participate in the case themselves outside of, what the ANC would be doing. So, I mean, as Lily has said, one of the things that we are trying to propose to do is to increase that sort of broader notice, so the general public is on notice of what's happening in front of the zoning commission or the board and can do their own research, dig into things, and then participate themselves independently outside of what the ANC would be doing. So there is that part of it. In terms of the great weight, the commission or the board has to give great weight to the legally relevant issues and concerns that are included in the ANC report. But again, if they are hearing from, members of the community, both the commission and the board, do want to hear that, and they will take that into consideration as well. So hopefully between the two of us that got to everything, but let us know if you have any follow-up questions.
Okay, I don't see a follow-up in the chat. So, and I don't see anyone's hands back up. So is there another section? We can move on.
Yes, of course. Okay, so I think we have this and then one more section. So OAG also has some concerns about amendments to the rehearing and reconsideration process. In OAG's original comments, we recommended that the regulations governing the commission's process be amended to reflect that which is in the board's process. So basically provide more clarity on the definition and standards of a rehearing and a reconsideration by distinguishing between issues of fact, which are meant for rehearing, and then issues of reconsideration, which are meant to provide a revised final order. OP and OZ did incorporate this distinction in their updated proposal in response to OAG's comments, so we are very happy to see that. But it did not include the full remedies for motions for reconsideration, so we're hoping that that be included after this round of comments and feedback. Second, OAG is concerned that the proposed amendments would limit the usefulness of a rehearing or reconsideration to allow the commission to address issues in a timely manner instead of forcing opponents to file a lengthy appeal. And I realize I may have gotten ahead of myself, so I'm just going to back up for a second. This is after a final order in the process. A final order has been issued. If anyone has opposition to it, their recourses are to file a motion for rehearing, reconsideration, or appeal it to the DC Court of Appeals. The motion for rehearing is appropriate where there's evidence that has come to light that was not available when the hearing took place. And in that case, the zoning commission or the BZA should conduct a new limited hearing on that new information. If there's an issue of the law being applied to the facts incorrectly in the final order, then the appropriate recourse is to file a motion for reconsideration, and the board or the commission will reconsider its final order and issue a revised order if appropriate. And an appeal is then a separate process before the DC Court of Appeals, and that takes 2 or 3 years. The proposal by OP and OZ is trying to state that if an appeal is taken to the Board of Appeals, the commission will no longer have the ability to reconsider or rehear it. So basically it takes away the ability of someone to process their concerns with the final order before the commission. The commission can process these concerns and address concerns with their final order on a much shorter time frame than an appeal can. So OAG's proposals, I'll go back to it for a second, is seeking to really make it easier and broaden the ability of anyone to bring a motion for reconsideration or rehearing before the commission. And in this way, we hope to make it easier to bring issues to the board instead of to the Court of Appeals. So specifically, OAG is concerned that the proposed amendment would bar non-parties from filing a rehearing or reconsideration motion, even though non-parties are allowed to bring appeals to the DC Court of Appeals. So currently non-parties cannot bring, if they have an issue with the final order, their only recourse is to bring an appeal. We want to allow them to bring motions for reconsideration and rehearing, again, as I said, to make it less likely that an appeal will be brought. And second, OAG is concerned that the proposed amendment automatically dismisses a motion for reconsideration or rehearing if an appeal is filed, which would allow anyone to foreclose a motion for rehearing or reconsideration by filing an appeal and taking away the commission's ability to address that issue on a shorter time frame. So we are seeking to allow non-parties to file these motions. We're seeking to extend the time frame that people have to file these motions from 10 to 30 days. This aligns with the DC Court of Appeals rules, which allows 30 days for appeals. And third, we seek to allow motions for rehearing and reconsideration to be decided by the commission regardless of the filing of an appeal. So the commission doesn't lose the ability to address this if an appeal is filed. And this helps address the cases where if there's an obvious error in a final order, the commission has the opportunity to address it. There are cases where there were issues with the final order that got appealed, and because for the BZA, when the appeal happens, the BZA loses jurisdiction to address those motions for reconsideration. They weren't able to address it. The case got appealed, got remanded, and they were told to address that exact issue. So it just extended the timeline by a year at least, and we're hoping to avoid that scenario. So in these ways, we're seeking to resolve opposition to final orders without forcing opponents to appeal, but to allow them to raise their issues directly with the commission, who can address it on a shorter time frame.
Yep. Okay. Questions can, are you taking questions for this section? I'm sorry, it just went on. And
Yeah.
so, okay. I don't see anyone, but I actually have a question and just one for clarification. Can you clarify, can ANCs take a case to the Court of Appeals? I thought we were barred from doing that. ANCs were prohibited.
Alex, do you know? I was not aware of that.
No, so ANCs are not able to bring an appeal as an ANC to the Court of Appeals currently.
That's what I thought.
Yeah.
So everyone, I want to clarify that. So the recourse, I guess, then to clarify, so everyone's on the same page, because I was a little confused. For ANCs, it is a rehearing or reconsideration at that rate. That is the extent after a final order has been issued, correct? Okay, great.
Thank you for clarifying that, Gail.
I will just
No
say,
problem.
follow up on that. An individual ANC commissioner in their individual capacity could bring an appeal, but just not the ANC as an entity itself.
Exactly. Okay, great. I just wanted to clarify that for some of the new commissioners. We do have one question before we move on to other concerns. So I'm going to take that from Commissioner Edwards, and you're going to be unmuted in just a second. You're unmuted. Go ahead.
Thank you. I'm a new ANC commissioner, and a lot of this is Greek to me. But I'm swamped right now, and this seems to be placing more administrative burdens on us. Are there tools available by which this can be easier for us to negotiate and comply with any new requirements that arise as a result of these changes?
Sure. So I actually don't think that we're placing or even OP or OZ's proposal is placing much more burden on ANCs. And if you have specific cases where I'm wrong, please correct me, because that's absolutely not what we're trying to do here. We're really trying to make this process more efficient, provide more opportunities for ANCs to review applications, and so that they're not rushed to review an application right away, but they have time to discuss it. The racial equity requirements there's no requirement from ANCs to participate in the racial equity process unless they themselves are submitting an application or petition. The appeals process, as I said, or as Gail mentioned, only if they see a problem with the final appeal and they decide to take action on it will these changes affect them.
I was a little concerned about the racial equity requirement. Can the community, if the ANC decides not to submit an application, can the community say that it was derelict in any way or that it didn't fulfill its compliance requirements?
So an ANC would only be required to do a racial equity requirement if they are submitting a case before the zoning commission or before the Board of Zoning Adjustments. And so that would be like if your ANC wanted to do a map amendment and they submitted a map amendment application to the zoning commission, then they'd have to do a racial equity requirement. If some third party individual came and said, we're trying to build a PUD, then the ANC and it's in your ANC, you have no requirement to do a racial equity analysis, at least under the zoning regulations. So really it's only in the case when you're proactively trying to change something before the commission or the board in which you would be required to do a racial equity analysis. Does that help clarify things?
Just to also follow up on Lily's comments, Commissioner, is that when in those instances where it is an ANC that is bringing a case, be it a map amendment or a text amendment or what have you, the regulations is proposed in 2225. In this case, OP and OZ actually have made a little call out saying that in terms of coordinating outreach to the community and sort of figuring out some of the logistics, they do sort of provide the Office of Planning and OZ as a resource to ANCs to help them with that. And that's sort of the other thing that we're trying to get to with our proposals is just to make the whole process clearer so that it is easier for ANCs to sort of navigate if they are in that role. And then finally, the other thing I'd point out is that, it is clear in the zoning commission's new tool that, doing the data mining, going and getting all the information out of the census, that is going to be done by the Office of Planning. So that would not be something that the individual ANC would be charged to do. You would be coordinating with the Office of Planning to get that information.
That helps a great deal. So it's not our responsibility to do the data mining. It is the Office of Planning's responsibility, and we just coordinate with them on that, because I was concerned about how much data we were going to have to dig up.
Yeah, OP's responsibility. Yeah.
Okay, great. Thank you very much. That helps a great deal.
Thank you, Commissioner Edwards. Okay, we're ready to move on to the last section.
Okay, yeah, these are just a few concerns that actually ANCs and members of the public raised in their comments in response to the original 2225 proposal. And so we've reviewed those and we are very grateful for everyone that submitted those. One thing that this updated proposal is seeking to do is to make it so that comments, applications, and reports may only be filed electronically. But we understand that not everyone in the district has access to a computer or the internet, and thus we want to ensure the process is truly accessible to all. So OAG is against the amendment seeking exclusive electronic submissions. And second, the proposal is seeking to expand a provision that allows, in cases where there's a condo with 24 condos or more, that notice only has to go to the condo board. OIG is against this amendment. There's no guarantee that a condo board will give actual notice to each condo owner, and OIG thinks it's important for neighbors to receive actual notice of projects within 200 feet of their property, which is the instances in which they would receive notice. There's one change that OP and OZ are seeking to amend in this case, and that's there's a slight provision to a change to a provision. I don't have the provision here, but a few commissioners mentioned it, and it basically says and it says has or, and so it allows cases before the BZA to applicants for the BZA to submit either a statement of the efforts they have made to contact ANCs in the community or a statement of their plans to contact the community. We want to be clear that we don't think that just saying what you have done or what you're planning to do is enough. We want to change the or to an and, which will basically ensure that applicants have to say what they have done and what they plan to do. And so if they haven't done anything yet, then they have to say that, and then they have to say what their plans are, and then they have to update that closer to the hearing to say what they actually have done, if they've complied with their plans or not. This is a list of recommendations that OIG previously made that OP and OZ took into account and updated their proposal with, so we're really grateful for that. And this is our public contact information, so please feel free to reach out to us with any comments or questions or suggestions about this or any matter. I'll pause and we can go have a discussion about any other thoughts or ideas for this case, but we wanted to thank everyone for participating, and yeah, I'll turn it over to you, Gail.
Great. So I'm going to just open it up for other questions as they relate to the map amendment and the changes to 22-25. I did see a few questions in the chat that would be more to our zoning 101 training that the OAG did for us. These questions, or please keep your questions to the actual changes to these map and text amendments that are before that the Office of Zoning and the Office of Planning have put forth and are going to be up for the hearing on June 12th. So with that, I'll open it up, and I believe Commissioner Elkins has his hand up. So give me a second, and you're unmuted.
Good, thank you. There are a couple of additional amendments that I would hope that OAG and my fellow commissioners would support. OAG is already familiar with these. I'll brief them on it, but if I could just take a couple of minutes with my fellow commissioners. One is, I find it frustrating that the rules say that if you give oral testimony in front of either one of these bodies, that you only have 7 days to get confirmation from your full ANC to show that, in fact, your testimony should be given great weight. That 7 days is something that they are required to allow under the statute, but I read the statute as being more liberal than that, essentially allowing the Office of Zoning to give more time than that. And I'm suggesting language that would go something like that they can receive this confirmation that it is that this testimony does represent the the views of the entire commission at any time prior to the date of a commission meeting to consider, that's the zoning commission meeting, to consider final action, including any continuation thereof on the application. This is language taken from other parts of the rules. The idea being that if we could get the full commission to endorse the testimony of an individual commissioner before the action is taken by the zoning commission, then it would be given great weight. The other proposal is that recognizing that redistricting has taken place, that in fact, perhaps the most knowledgeable ANC is on a particular case is no longer involved in because of redistricting in that particular facility, and yet they might have a lot to offer. I did notice that they could sign up to be notified, but I think that requires action, forethought on the part of the ANC. I'm think we should recommend that the former ANC should be informed. That sounds like a burden, but in fact, it shouldn't be. It should only take the applicant about 2 or 3 minutes to do that, because OP has the ability to tell the applicant who was the previous ANC. We had that database that all of us could use until December 31 on the previous districting. I'm sure that still exists. So I'm suggesting that the former ANC be notified, not to give them party status or any special rights, but simply to be notified so that they could then lend their expertise, if they wanted to the ANC that now has a responsibility for the matter. So those are two things. You'll find explanation of this in the record because I did file this testimony. But if you don't want to do that and just want to know more about the justification, I'll be glad to send you my testimony or talk to you about it. And my address is 3D01. That's my SMD, 3D01. Thanks very much.
Thanks, Commissioner Elkins. I do have a question. I believe it's from Commissioner White, but it has to do with racial equity, and I'm not sure that I'm asking it correctly. She put it in the chat, and she's asking me to read it. But so it has to do with the racial equity analysis. And is there any changes in these text amendments or that would require the developers to submit the analysis for any zoning relief or map amendment or PUD? So either contested or what is text amendments called? Whatever that term is.
Yeah.
I know contested. I don't the other one. So I guess that's her question. I'm hoping that's her question.
Yeah, so OP and OZ did include a requirement that contested cases and rulemakings, the applicants or petitioner in those cases submit the racial equity analysis per the racial equity tool on OZ's website. What OP and OZ put in the regulations is just basically use the tool on the website, and what OAG is hoping to do is just to beef that up a little bit, make sure that the actual requirements of who does what at what point in the process be spelled out in the regulations, so it's really clear. And that means that there's not going to be confusion. There's going to be some minimum standards as to what is expected as part of the racial equity analysis, so that we can actually see the impact of the applications. Is there a mitigation required? So currently there's not mitigation required. And I think what you mean by this, Commissioner White, and please correct me if I'm wrong, is that if for some reason the racial equity analysis shows that there would be an impact, whether the applicant has to provide some kind of mitigation. I believe it is OP's position, and I don't want to speak for them, but that the racial equity analysis is not meant to assess necessarily how big of an impact it will have. It's more to understand the context in which the development is moving forward in, and to conduct outreach to targeted communities. That OAG has conducted research on how racial equity analysis take place in other jurisdictions and other cities. And I think obviously we'd like to see a bit more of that, but the requirement for that in the comp plan isn't necessarily as strong. And so while that is maybe the best case scenario for a racial equity requirement, racial equity analysis, what is currently required in the comprehensive plan is a bit less than that. And so we absolutely encourage you to voice that opinion to the zoning commission. They have said that they're open to changing this tool and to updating it. And so I think the more that they hear that, the more they'll be encouraged to include that type of analysis.
And I do believe that the Office of Zoning is planning another round of roundtable on the racial equity tool. I think the Chairman Hood made that statement some time ago. So, okay. Well, we are getting to the bewitching hour. I don't see any more questions. So at this point, we do have, oh, you have a new I guess, general email box, which is landuse@dc.gov. And so that's, you want to talk to that, Lily, just because
Sure.
it's a little different.
Yes. Thank you. And I just want to mention one thing that I forgot as well.
Okay.
But this is our new email address. It's landuse@dc.gov, a bit easier to remember than all of our individual names. So we're monitoring that and we'll be able to receive emails through that. Please feel free to share it widely. I know there's some new commissioners here. If you have any questions or concerns or just want some additional training, we're happy to be of assistance in any way. So feel free to reach out. And also, I just really want to say thank you for everyone for coming and for participating in this case. It's an important case about the zoning procedures. And if you have thoughts or feelings about any of this, that we encourage you to submit them, your comments to the Zoning Commission for the hearing, which is scheduled for June 12th at 4 p.m. And so if you need help in any way submitting comments, feel free to reach out to us. We're happy to help.
Excellent. Thanks so much. Again, I just want to thank everyone for attending today. This training was recorded. This roundtable, it's not training, roundtable was recorded. So we will get it up on the YouTube channel, the OANC YouTube channel. So for any of your colleagues who may have missed it, they'll be able to access it and listen to sort of what we learned today to help them frame any other additional testimony they'd like to submit before the June 12th hearing. So without that, thank you, Lily. Thank you, Alex. Thank you, Max. Thank you, interpreters, and thank you, ANC commissioners, for attending today. Take care.
Thanks, you too. Bye, everyone.